I welcome you all for the class on Indian polity. Today we will take up Article 33, Exception to Fundamental Right. As you know, in the last class we have already taken up the 6 fundamental rights, including Article 31A, 31B and 31C. Today we will take up Article 33, which is an exception to the fundamental rights. Article 33 empowers the Parliament to restrict or abrogate by law any fundamental right with regard to two groups of persons. Remember, one is members of armed forces, second is members of paramilitary forces, that is the forces charged to the maintenance of public order. So these two groups, in respect of these two groups, Parliament can make law by deriving powers from Article 33 to restrict or abrogate their fundamental rights, number one. Secondly, 50th Constitutional Amendment Act 1984. 50th Constitutional Amendment Act 1984 amended Article 33 and extended its scope, purview, by including two more groups of people, in addition to what I have already mentioned, that is the armed forces and the forces who are made responsible for maintenance of peace and tranquility. These additional two groups of people included, and as per the 50th Constitutional Amendment Act 1984, were, number one, the members of the Bureau established by the state for collection of intelligence. In simple terms, intelligence bureau members. Secondly, the persons deployed with the telecommunication system set up for the establishment of armed forces, intelligence bureau, and paramilitary forces who are made in charge of public order and maintenance of tranquility. Remember. So, first two groups, second three groups, IB and telecom system. These two groups and earlier two groups. Remember. So, these four groups, law can be made to abrogate their fundamental rights. Now, deriving powers under Article 33, Parliament enacted, as you know, the Army Act 1950 and Air Force Act 1950 and Navy Act 1950, Police Forces Restriction of Rights Act 1966, BSF Act, etc. The members of the force include the mechanics, carpenters, cooks, chowkidars, and other categories of people who fall under the non-combatant, that is, they are not in the warring side. They are inside working, they are not in the forefront. And what is the purpose? The purpose is to ensure proper discharge of their duties and to maintain discipline. If there is no discipline among them, they cannot accomplish their targeted objective. So, obviously, the 6 freedoms given in Article 19 do not apply to this group of people. So, the power to make law, remember, is only with the Parliament, and state assemblies have no powers. No powers. Remember, state assemblies has no powers. Then, this article is an exception to clause 2 of Article 13. This article, that is Article 33, is an exception to clause 2 of Article 13. Why? Article 13 clause 2 says that the state shall not make any law which takes away or abridges any of the rights conferred in Part 3 of the Constitution. If any law is made taking away or abridging any of the rights conferred in Part 3 of the Constitution, that law, to the extent of repugnancy, is null and void. So, if any law is made under Article 33, that law will not be subjected to judicial review. It is an exception to Article 13, Clause 2. Remember, that is the most important factor. The judicial review will not apply here. Similarly, Article 13 can also exclude court-martial from the writ jurisdiction of the Supreme Court and High Court. In nutshell, remember, from the examination point of view, number 1, Article 33 is an exception. Article 33 is an exception to fundamental right. Number 2, Article 13, Clause 2, that is the judicial review, does not apply to any law made under Article 33. Number 3, 50th Constitutional Amendment Act 1984 added 2 more group of people, that is Intelligence Bureau and telecom personnel working in the armed forces, public order organizations and also Intelligence Bureau. Armed forces include non-combatant also. Fourthly, the power to make law is only with the Parliament and state legislatures cannot make such law. The purpose is to maintain discipline. So these members cannot form union, cannot form association, cannot demonstrate, cannot participate in strike, cannot attend public meeting and cannot interact with the press. These are all the restrictions available given to the 3 group of armed forces, paramilitary forces, Intelligence Bureau and those working in these 3, telecom personnel working in these 3. Remember, with this we complete the Article 33. Now we are coming to Article 34, very important chapter regarding martial law. Remember, martial law has not been defined in the Constitution. Martial law has not been defined in the Constitution. In fact, this concept has been derived from English law. Technically, what does it mean? It means a military rule. There is no provision in the Constitution at all. It is only a military rule. It refers to a situation where the civil administration is run by the military, army people. So it refers to a situation where the civil administration is run by the military authorities as per their rules, outside the purview of the ordinary law. So there is no provision under what circumstances martial law can be ordered or declared. Nothing is there. But it is obvious that from Article 34 that the martial law can be declared in extraordinary circumstances like war or rebellion or insurrection or revolt, etc. The purpose is to restore the public order and repel violence and to ensure tranquility in the area. Normally, this can be imposed only in the disturbed areas. Remember, only disturbed areas. The Parliament may by law. Actually, if you see the Constitution, straight away it says what are the powers of the Parliament. It never said about the circumstances under which the martial law can be imposed. Straight away it says Parliament can indemnify any person in the service of the Union or in the service of the state in respect of any act done to preserve or restore public order and tranquility in any area where the martial law is in force. The indemnification validates any sentence or any punishment ordered, any forfeiture ordered, etc. An act of indemnity passed by the Parliament is beyond judicial review. Most important, beyond judicial review. The power of the Parliament is upon 2 conditions. What are the 2 conditions? Martial law should be in operation. Martial law should be in operation. Secondly, the purpose of martial law is to restore public order. Nevertheless, remember, without declaring martial law, Parliament had enacted many laws granting special powers to Indian armed forces and the states and paramilitary forces only to ensure tranquility, peace and public order in the disturbed areas. The purpose is only to restore public order. For example, recently Armed Forces Special Powers Act was extended to Nagaland. In fact, it was earlier there in Assam and Nagaland. It was there already. This act also gives powers to army, central and state forces to search any house, to shoot anybody who are indulging in violence and to kill anybody and to destroy any property which are assisting the rebellion. Remember, the forces can arrest any person without any warrant. The purpose is only to curb the violence and also to restore the peace. The act has the origin of Armed Forces Special Powers Ordinance of 1942, which was literally a license to kill, promulgated by Viceroy Lincoln. After independence, as what is called Armed Forces Special Powers Act was Assam and Manipur Act of 1958, then Armed Forces Special Powers Act of Punjab and Chandigarh 1983 and Armed Forces Special Powers Act of J&K of 1990 were promulgated. Remember, from exam point of view, from the examination point of view, remember the important points. Martial law is different from national emergency because during national emergency, the assembly functions, parliament functions, council of ministers functions, President of India is bound by the advice of the Council of Ministers. All these things functions. Only fundamental rights are suspended except Article 20 and 21. Whereas in the case of martial law, only it can be declared only in some areas, disturbed areas. Remember, there is no provision in the Constitution to declare martial law in entire country. It can be declared only in some areas. Similarly, it affects only the fundamental rights, maximum fundamental rights. And the purpose is to restore public order. And it suspends only the government, executive and ordinary court. There is no provision in the Constitution to impose martial law in the entire country. This is nothing but the legacy of Viceroy Lincoln's what is called Armed Forces Special Powers Ordinance of 1942. With this, we end the class. So we have completed Article 33 and 34. 35 is left. We will take up the Article 35 in the next class. Thank you.